I have a couple of matters to think about here. The first one is somewhat sad. For those of you who may know, our colleague Judge Dinkins passed away day before yesterday. He was a wonderful judge and an even better friend and colleague, and we miss him very much. And we would like to have a moment of silence in his memory, please. Thank you. On another point, today's docket, we have second on the docket is the Martell Foundation versus Kraft CPAs. Is anybody here from that case?
I see Mr. Leathers in the crowd there.
There's Mr. Leathers. Well, everybody seems to want to abandon you. We have a motion from the Martell Foundation's attorneys asking to just waive oral argument. We understand the other parties were willing to waive argument as well, yet we have not received anything from them, but they are not here. So it's looking like that's not going to happen. So when we call it, and if nobody comes, I understand you weren't going to argue today anyway, right? You were just going to watch. So
solely to observe the argument.
So if nobody shows up, we'll just put it on the on brief docket. Okay. Thank you. Okay. I think I've taken care of all the other stuff now. When we call your case, we'll call them in the order it appears on the docket. Please come up and you can reserve, the appellants can reserve up to 5 minutes for rebuttal. And please, everyone, remember to try and speak into the mic. It's particularly important when you know, Judge Golden is listening from a very long way away, and so speaking into the mic helps him a lot. There being no other matters, would you call the first case, please?
Patrick Stockdale et al. Versus Kim Helper.
May it please the court, Bryant Kroll here on behalf of the appellants Patrick Stockdale and Shane Dunning, who are in the courtroom today with us, along with my co-counsel Gary Blackburn on this case. I'd like to reserve 3 minutes for rebuttal.
3 minutes, yes, sir.
This is an interesting case. In fact, it seems to be so unique. There's not really any cases that are directly on point. And so the federal courts involved looked to other cases, and Fourth Circuit, I think, was some of them. And this gets up to the Sixth Circuit Court of Appeals on the issue of prosecutorial immunity. At that point, 3 different judges in the U.S. District Court had denied absolute immunity for General Kim Helper's conduct and had also refused qualified immunity. And the facts of this case, as cited in the Sixth Circuit decision...
Please pull the mic towards you a little bit.
Absolutely.
Thank you.
So this case gets up to the Sixth Circuit, and they find that General Helper is not entitled to any absolute immunity, but then reversed the denial of summary judgment on the issue of qualified immunity. And we respectfully disagreed with that decision, but the Supreme Court wouldn't take up either one of our petitions, and so they refused to rule on the
Well, you
state law
only
claims.
partially disagree with that opinion, I'm assuming, right?
Well, we
They got it.
disagree with-
I mean, you think the Sixth Circuit got it at least half right?
They got half of it right, Your Honor, they did. And I think it's because the unique facts of this case are that General Helper interfered with municipal affairs and had no authority to do so. She was not employed by the city of Fairview.
So I'm struggling with abatement in this case. I mean, it seems like to me this is exactly the sort of situation where abatement should occur, because you have a new DA that steps into General Helper's spot, and they can make their own decision whether or not these two gentlemen can properly testify. So why hasn't this action abated?
Your Honor, first, there's never been a case in Tennessee or really any other jurisdiction that has held that a tortious interference with business relationships or prospective relationships applies to where it is abated. These cases.
But isn't the heart of this case about character? I mean, isn't that what it's all about? Is that you're saying General Helper made a bad call about your two clients' character in this case?
Well, it wouldn't happen again for several reasons with the new DA in place. One, a lot of the facts that we cited were in relation to General Helper's pick for candidate, her DA or her district's drug task force member, and the unique scenario of Fairview looking for a chief of police. But we look at the nature of claims that are abated under Tennessee law, and this is just straight to the statute. These are claims affecting, wrongs affecting the character of the plaintiffs, so then the issue becomes whether tortious interference is one of these claims that should abate. Now, no case has held so at this point, but we look at really what is protected by the tort of tortious interference. And I found this in reviewing for today's oral argument. This is from the Trial Med decision that we've cited in our brief, and that's 71 Southwest 3rd 691. This is footnote 4 in that decision. And it says, the relations protected against intentional interference by the rules stated in this section include any prospective contractual relations, except those leading to contracts to marry, if the potential contract would be of pecuniary value to the plaintiff. So we're looking at pecuniary value of contracts or of business relationships, but they specifically include contracts to marry, and then you go look at the abatement statute itself. And although these torts have been abolished, the seclusion or seduction rather, and the interference with marital relations, when you look at what those torts actually protect, and we cited this in our brief, those types of character elements, particularly with seduction or alienation of affection, those involve the plaintiff's good character as part of countering the defense. So, and forgive me for the dated language, but things like such as whether the woman was chaste and things like that. These are very personal things that are not at issue with the tort of tortious interference. Now, defamation claims do abate, and that is because you receive, it's to protect your character. That's what's damaged. But here, we did allege in one of the, I believe it was in the federal court case, we did allege defamation, and it was dismissed and we never produced it. So we don't have a defamation case. We don't have, that's no longer really an issue at all, is their character. It's about this business relationship, and that is their employment with Fairview, City of Fairview. And in footnote 5, they talk about this in Trial Med. This is that it talks about protecting employment, prospective employment, things of that nature. So the damages for this case are back pay, you have compensatory damages, but there's no specific category for character that would be something for the jury to decide, as there are in these other cases that abate. So that's why abatement doesn't apply in this case. It's one, it would be a new rule, be a new category, a new exclusion. And at some point, I tried real hard to figure out what other courts have said on it. And I pulled out my old dusty Prosser and Keaton on torts, and they said that the early cases really across the country were pulling back from including more and more torts as that not falling within these abatement statutes, because at some point it's a denial of equal protection. You're picking and choosing torts that historically didn't have anything to do with the character of persons. And no case has been cited by the defendant which says that tortious interference protects those relationships, or that tortious interference is a case affecting character. We couldn't find any to distinguish, but that's just simply because it doesn't apply. Again, this is about business profits. You're talking if you own a business, for example. But for these two lieutenants, it was employment, salary, and then of course just compensatory damages. But if compensatory damages was what courts looked at, then every case would abate upon the death, and we'd be back to the common law rule. The exclusions would swallow up the whole statute itself. So this case didn't, under these facts anyway, don't abate. I think if it would be a different scenario if we still had a defamation claim, for example, and those facts that supported defamation also supported this, but they don't. The essential facts for tortious interference are that the defendant acted with improper means, improper motive, I'm talking about malice. And in footnote 5, they say it is in this trial med, it is clear that a determination of whether a defendant acted improperly or possessed an improper motive is dependent on the particular facts and circumstances of a given case, and as a result, a precise, all-encompassing definition of the term improper is neither possible nor helpful. And in this case, the improper means was the fact that General Helper didn't have any authority whatsoever to do what she did. And that's clear from the Sixth Circuit case why they denied absolute immunity. And the trial court erred when it found that she was entitled to send the email. This is just totally contrary to everything that the Sixth Circuit held. And said that she should be. That's essentially ignoring the functional approach that the Sixth Circuit of the United States Supreme Court has held that you have to apply in order to find out whether a particular act is a prosecutorial act. So if giving advice to a police agency in the context of trying to search for clues or sniff out clues, as the Supreme Court said in Buckley versus Fitzsimmons, that doesn't have the shield of judicial intervention at that point. No prosecution has been initiated. The defense.
Mr. Kroll, let me move you along here because I know we're running out of time. I want to move you over to qualified immunity. Let's talk about that. Do I understand your position to be that qualified immunity is not applicable to a common law claim in Tennessee?
Your Honor, that is true. Yes, this is the qualified immunity of federal courts. The first time that this has ever been applied, the federal qualified immunity for 1983 actions has ever been applied to a state law tort of this nature was done by the trial court below. So it doesn't apply.
How do you reconcile that with Youngblood and Kaywood? Which in fact does say that we have qualified immunity for state law claims, state common law claims in Tennessee.
Well, in those two cases, Your Honor, they did. If you look at a malicious prosecution claim, and we got to go back to remember that you can bring a malicious prosecution claim under state law and under 1983. And so it makes sense that the same set of facts would apply, because the element for malicious prosecution, the very first one, according to the Tennessee pattern instructions, is that the defendant started or caused someone else to start a proceeding against the plaintiff. That's immune. You're immune for that.
There's nothing to indicate that it's limited to peace officers or whatever. There appears to be a standard, though, that's used, and the standard is reasonableness. And can that not be applied across the board for state employees to determine whether or not there's qualified immunity?
Well, if it was only reasonableness, Your Honor, then that would essentially sidestep Buckley versus Fitzsimmons, Burns, all the Supreme Court precedents as about whether or not it's a prosecutorial act. But you cannot be qualified immunity in the federal context because under that application, as what happened below, it's essentially creating a new absolute immunity because the right to be free from tortious interference isn't exactly it. But if it's reasonableness, I don't think that would work in these cases. I think that there is
reasonableness is not the federal standard under 1983, but it appears to be the state standard as far as this court's concerned under Kaywood and Youngblood. Reasonableness seems to be the standard. Do you disagree with that?
Your Honor, I believe in this particular case that it was a question of fact for the jury as to whether or not her conduct was not improper. That sort of gets to a reasonableness analysis, but under the state law torts, no court in this state has held that, whether it's the Court of Appeals or the Tennessee Supreme Court, that qualified immunity or any type of qualified immunity, whether that's discretionary immunity or anything else, applies to this particular tort. That's the first red flag. The second one is that reasonableness would essentially create more confusion when it comes to a prosecutor. But
you didn't challenge the court's finding of reasonableness in this case, though, did you?
Your Honor, I don't believe reasonableness was a particular grounds in here. She said the court, this was in the context of whether the immunity applied, said that as the chief law enforcement officer, it was part of her duties to.
Well, let me quote the judge's order here. The court said the court finds the plaintiffs did not have a clear established right to be free from communication of a district attorney's gigolo decision to their employer. And then it goes on to say, the court finds it was reasonable. General Helper voiced her concerns about the plaintiff's professional performances to a person of authority over the plaintiffs. So the court did make a finding of reasonableness in this case, didn't it? Which is what isn't that the Tennessee standard?
Well, reasonableness in that context, Your Honor, contradicts with the absolute immunity and qualified immunity analyses. So it can't really fit within it. And Youngblood was a GTLA case as well. So the facts of Youngblood and the reasonableness under that, it's really for discretionary immunity. But for discretionary immunity to apply, you must first be acting within the scope of your duties. And we alleged and respectfully proved sufficient that it should have been a jury question as to whether or not she was acting within the scope of her duties. So reasonableness, I think, would be incomplete, and in this regard was part of an explanation for denying absolute immunity.
So it's your position that qualified immunity doesn't apply to state law claims. Am I understanding that correctly?
Unless it's for malicious prosecution or false imprisonment. In other words, if there's a finding, and really, Your Honor, it falls, these cases are decided on absolute immunity. If there's a finding that she's acting within the scope of her duties under the Supreme Court precedent, Sixth Circuit precedent, or something else, then you don't really get to the next section. So that's really what Willett and the other two cases that cite Willett are about. The fact that there really isn't a qualified immunity. Qualified really just means that it can be defeated by showing of malice. That's what a qualified immunity is. But reasonableness really wouldn't meet the standard. It would be a lack of malice, and I guess the defendants demonstrate this by showing that there was no clearly established right for a constitutional tort. But you can't apply that to a claim unless there is a tort. So a constitutional violation, that is. But it doesn't work for intentional interference with a business relationship.
And so am I understanding what you're saying is that unless it applies in a constitutional framework, then it doesn't apply to a common law claim?
That's correct.
I think that's what you're saying, but I'm trying to understand it.
There's other immunities that also don't apply, discretionary function immunity under the GTLA. There's other immunities that we've argued don't apply, but it wouldn't apply to these state law claims. That's correct.
All right.
Your time is up.
Thank you.
You still have your rebuttal time. General Ross?
Thank you. Good afternoon, Your Honors. I'm Heather Ross. I'm with the Attorney General's office. I represent General Helper in this case, and as you are aware, General Helper passed away in March, and so her personal representative...
I'm sorry, Ms. Ross. Could you please speak into the mic? I can't hear.
I am much shorter than Mr. Kroll, and I apologize for not...
Thank you very much.
General Helper's husband is the personal representative who has stepped in as the place marker, so to speak, for the defendant. This case should remain dismissed for 3 reasons. First and foremost, it should abate because this case does involve wrongs affecting the character of the plaintiff. But even if this court does not issue an abatement order, it should still uphold the trial court's dismissal because the trial court was correct when it determined that General Helper is entitled to absolute immunity for all the actions allegedly taken. And the trial court was also correct to say in the alternative, General Helper is entitled to qualified immunity, both of which would bar this action completely and the dismissal should stand. Now it is true that many actions do survive the death of a party. But the legislature was very clear in Tennessee that an action for wrongs affecting the character of the plaintiff abate upon the death of the defendant if the defendant prevailed in the trial court. The legislature did not name a claim. It didn't even talk about the nature of a claim. Instead, it used a descriptive phrase. It's an action for wrongs affecting the character of plaintiffs. It must be presumed that the legislature chose its words for a reason. Those words are extremely broad. When courts look to see if a case must abate, it goes to the substance of the claim. It looks specifically as to whether or not damage to reputation might be involved. It goes to whether the credibility of a plaintiff or their character comes into issue. For example, in malicious prosecution, false imprisonment, false arrest, the state courts have determined that those involve reputation, and as such, they abate upon the death. And of course, libel and slander, plaintiffs explained that they had brought a libel slander case based upon these same allegations, but they didn't bring one here. They just brought it in federal court. But thirdly, the courts will look to whether the plaintiffs have brought their character at issue, precisely because the defense may raise it. And those kinds of cases are breach of marriage contract or seduction, cases like that. And this case falls squarely in the abatement statute. The entire genesis of this claim is that General Helper allegedly wrongly giglio impaired the plaintiffs. By definition, a giglio impairment means that the prosecutor believes that information exists that could cast doubt on the credibility, the truthfulness of the plaintiffs. And by virtue of U.S. versus Giglio, she would then have the responsibility to hand that information over to criminal defense. A giglio impairment goes directly to the credibility or the truthfulness of a witness. It goes directly to their reputation. It also goes to their character And indeed, when it comes to reputation, the plaintiffs themselves alleged that the Giglio impairment is an act of such universal significance in law enforcement communities that it will effectively end any officer's career. So,
General, uh, uh, isn't that effectively an employment decision? Isn't this an employment? Doesn't that make it an employment issue more so than a character issue?
when we're talking about what types of cases abate, it does not matter the character of the claim. What matters is whether or not an individual, the plaintiff's character, will come up at issue, and whether the plaintiff's reputation will come to issue. And that is why when you look through the catalog of cases that have abated in the past, they run the gambit, all the way from malicious prosecution to libel to breach of a marriage proposal. And in this case, you do look to what was the genesis of the action that actually led to this allegation of loss of reputation throughout the police community. And it gets down to a witness credibility decision, which is that Giglio impairment. It directly affects the plaintiff's character, or I should say, it raises the question of plaintiff's character. For this reason,
So we look to that versus what the effect of that is. In other words, the effect of that creates an employment issue. So that's the part when you have a defamation case, it's pretty clear that involves character. Here it's a little bit fuzzier, I think.
not necessarily, because the same holds true with interference with contract. There might be a case out there, I'm sure there are cases out there that involve interference of contract, but in no way actually go to the character of the plaintiffs. This one does, so it abates. When it comes to an employment action, there are going to be cases out there that may have nothing to do with the plaintiff's character. That case would not abate, but if it does involve the character for wrongs affecting the character of the plaintiffs, then it would abate under the very broad descriptive phrase set forth by the legislature, not once but twice. It's in both the survival action if the defendant dies before a cause of action is filed, and after. And
Are there any
indeed,
Tennessee cases supporting that position?
It's a catalog of all the cases. The one that says that they look to the substance of the action is Bowman versus Hart, 33 Southwest 2nd, 58. And then the cases there, as you look through them, you see that that is what does occur.
All right, thank you.
And because General Helper did prevail in the trial court, this court should issue an abatement order. In this case, should be extinguished.
If we get past the abatement question and looking at the immunities that the trial court applied here, I'm having a hard time seeing absolute immunity based really on the reasoning in the Sixth Circuit. I mean, it seems like to me they made a pretty compelling case of why this type of conduct should not be subject to absolute immunity when you look at the entire context of what occurred here. Where is the prosecution we're looking at here so that you can apply absolute immunity? This is some future prosecution.
Blanket Giglio impairments are permitted. That is very clear throughout the case law I cited in my brief, but also just the pure analysis of what a Giglio impairment is. By definition, that decision must be made before trial, because you have to let the other side know about the potential credibility determination issue. Whether that decision is made because of the trial at the end of this month, next month, or 5 months from now, or 2 years from now, the analysis doesn't change. The existence of the material remains. You have police officers who, more likely than not, will testify again in criminal cases. And it won't change. The decision belongs to the prosecutor. And that decision was made by General Helper. And as I said before, a blanket Giglio decision is an accepted absolute immunity act. And the consequence of that decision does not change the character of the decision. I would submit that it's black letter law that a witness credibility decision is an act, an advocatory act, which is protected by qualified immunity. Once that decision is made, General Helper communicated it. But the state of Tennessee has often looked at acts of advocacy and determined that if another act is intertwined with the advocatory act, then it too gains the character of advocacy and is entitled to absolute immunity. And I direct you to Willett versus Ford, where the prosecutor, the act was he took the criminal defendant to the sheriff's office to turn herself in. That may not necessarily be a prosecutorial duty, but the court held that absolute immunity protected that act when she sued him later for malicious prosecution, libel, slander, outrageous conduct, intentional interference of emotional distress, all state court actions. The state court determined that those acts were intertwined with the malicious prosecution. Everything was protected by absolute immunity, and the case was dismissed based on absolute immunity. Similarly, in Savage v. Maryland, now that is a Fourth Circuit federal case, it also said essentially consequences do not define the act. In Savage versus Maryland, a Giglio decision, a blanket Giglio decision was passed on to the plaintiff's employer, and there was adverse employment action. But the court held that an adverse employment decision, even a reasonably foreseeable one, does not change the advocatory act. And because the communication was inextricably connected to the communication of that decision, I apologize, I think I just misspoke, but the decision was inextricably connected to the communication of the decision. And so the court continued to hold that it was protected by absolute immunity, as have other courts, other circuits, and other district courts in the federal realm.
Assuming that we were to agree that with the Sixth Circuit on the absolute immunity, can you tell us how qualified immunity would be applicable here?
Yes, and I would like to start with the initial statement that Section 1983, when it was created, federal courts borrowed from state court common law and incorporated common law immunities into the defenses for Section 1983. The state courts have also, and for that, in a similar vein, have certainly implied in Tennessee that it also is incorporating the federal standard for qualified immunity into state court actions. In King v. Betts, the court actually stated, quote, "It noted that decisions in federal cases are equally applicable to common law actions." And in Lucas v. State, which was a common law action as well, The court said the focus is whether the defendant public official's actions could be reasonably have been thought to be consistent with the rights they're alleged to have violated. Not constitutional rights, but the rights. They look at the rights. They are not bound merely by the constitutional or federal statutory rights, as well as Youngblood versus Klepper, when it said that it's the common law and Section 1983 action defenses were not created merely for the sole purpose of Section 1983. And a review of those cases show that the state courts do cite to and consider and accept the federal standards and the federal purposes for these different immunities, many of which include to allow a public official to act without being second-guessed by the judiciary, and also to allow a public official to act reasonably and sometimes mistakenly, but allow them to reasonably perform their public functions.
Mr. Kroll seemed to limit Youngblood to certain types of state employees, but it appears that Youngblood states that that the officer in this case was covered by a common law immunity afforded public employees performing discretionary functions. That wouldn't seem to be as limited as Mr. Kroll would have it seem.
Yes, Your Honor, I agree. And when you review all the other state laws cited in my brief, you see that the state courts are very amenable to not only quoting the federal standard and the federal reasons for different defenses, but at times do incorporate them.
The objection seems to be that the 1983 standard was used by the court, but it appears to me in that language I quoted earlier that Judge Ash actually made a reasonableness finding, and that would be consistent with common law immunity. Would that be correct?
That is correct. In the court, I actually followed your quote as you were speaking it, and that is correct. The court did make a finding of reasonableness and did find that particularly when the duties of the police and prosecutor are connected when it comes to criminal prosecutions. That he did explain his reasoning for that conclusion. I see that my time is up.
Yes.
Thank you, Your Honors.
Thank you, General. Mr. Kroll.
I'm going to do my best, Your Honor, to speed through this quickly. I will raise one issue. It's not cited in our briefs. This is a case that came down in January of 2023 and wasn't picked up, but it's another finding from the Sixth Circuit that I'll submit to the court if the court chooses to address it. But this is another one involving a prosecutor who did essentially what was done in this case. That case is Howard versus Livingston County. In the Sixth Circuit, it's case number 21-1689. And the Lexus citation is 2023 U.S. App Lexus 1540, and I'll file a copy of that with this court. But that case is just another example of why a blanket giglio decision and a communication to an employer is not proper. It's not a prosecutorial act. It is detached from the judicial function. And in response to the issue about this being an assessment of credibility, and that this being an abatement issue, it wasn't their credibility, the Lieutenant Stockdale or Lieutenant Dunning's credibility, that resulted in their termination. It was her refusal to prosecute. And City Manager Scott Collins said that he can't have he's a small force, he can't have two people that might not be able to testify in court based on her refusal to prosecute. He said that what she'd done was a disservice.
So this is all based on her refusal to prosecute. That's your position.
According to the city manager himself, it was that email. He couldn't get around it, and he couldn't have.
Well, you just said this was not a prosecutorial act.
It isn't.
Well, You said it was based on her prosecutorial decision.
It was based on her refusal to prosecute, but that's
Right.
a blanket decision that's detached from the judicial phase. This is not even a situation where she was giving advice to police agencies. That's the outer limit of absolute immunity. This was a decision where she interfered with the municipality. It wasn't even giving advice on a law enforcement matter. She was so far detached from the judicial phase, it wasn't the precatory acts that the courts have found in Buckley versus Fitzsimmons and Burns versus Reed are that, submitting an affidavit of complaint, as long as they're not testifying under Kalina versus Fletcher, that's a prosecutorial act. Indictments and information, those are prosecutorial acts, even though the prosecution has not yet begun. But here, we're talking about no case pending. Absolutely no decision could be made about the credibility of a witness at trial. These are what the cases stand for. And just briefly, and as to Youngblood versus Klepper, that case involved the Governmental Tort Liability Act, and this is at 406 in there. And that decision says the Court of Appeals held that the immunity afforded state employees acting within the scope of their duties did not apply because the accident had occurred prior to the date of enactment. But even in that case, first there must be a finding of acting within the scope of your duties. And when there is not, neither absolute immunity applies nor this type of qualified immunity that they've referred to as discretionary immunity would apply. But these are acts that aren't present in this case because this is not a GTLA case. But
Your time is up. Thank you, Mr. Kroll.
thank you.
Thank you, General Ross.